The witness is there to ruin your client's case. He's the enemy. You are hardly going to find him trying to help you. How many such cases are there? Because Harshad Mehta was one Dalal was another scamster. So he asked me, what's the total value of his scam? So I said, yes. He said, 50,000? 1 lakh? How much? I said, 1,53,400 crores. They just fainted almost. Fearlessness. Everybody is advised, all seniors are advised before that, do the right thing. And even if it means that you are unpopular, do that. You have yourself to answer. You have yourself to answer to on a lonely night. The same spine that you showed earlier, the same spine which would have told a judge that he can behave the same manner with a powerful man as he would with an ordinary pen pusher.
Hello and welcome to the Daily Lawyer podcast. My name is Jana Krishnan. I'm your host and the founder of the Daily Lawyer. And this is yet another episode in our Legacy series, which we present in proud collaboration with Solomon & Company, a law firm in Mumbai, whose legacy stretches across 115 years and across 4 generations. Thank you so much to Solomon & Company for being collaborators with us on this series and helping us bring all of these conversations to all of you. Our shared vision with the Legacy series is to immortalize conversations with those professionals who have made indelible contributions to the Indian legal system. We've already had 8-9 episodes, I think, on this series, and we actually want to also thank each and one of you, all of our viewers, because you leave such thoughtful comments on each of these videos and ask us for new guests that we have to bring. We take all of your recommendations very seriously, and today's guest was always part of our original list, but has also been requested by a number of you in our comments or in emails that you have written to us. I'm speaking about Senior Advocate Mr. Rohit Kapadia, Senior Advocate of the Bombay High Court, an alumnus of Government Law College, one of the most respected names in the Bombay Bar. He served as the president of the Bombay Bar for a 6-year term. He's also widely regarded as one of the sort of institution makers or mentors within the Bombay Bar ecosystem. He's had a long career within the law, has been part of really sort of headline grabbing cases, whether it was the Harshad Mehta scam or the Yes Bank stakeholder litigation. I am so excited to get into not just Rohit Bhai's life, but also just listen to various wisdom that he's gathered over the course of almost 60 years of practice. So thank you so much for being here.
Thank you very much, Anna. Nice to be here. I only wish you could be a little more truthful in talking about me.
All of that is true, and you're being very modest. But I did say a little bit that you're an alumnus of Government Law College, much like a lot of us here in Bombay. Can you take us back, if you have to start, take us back to maybe why did you think of doing law?
I thought of doing law. One reason is that my father was in the criminal law, and I had an uncle who was in the civil law, and I didn't get into medicine, which is what my first choice was. But medicine was inter-science. Inter-science, I lived more and learned less. So I didn't make it. Then I continued, and I thought I'll try for a first class in BSc, which after you get your first class, you can walk into the medical college. I got a first class, but the government came out with the rule of 3 years government service after MBBS. So I was not looking forward to my son earning before me. So I said, no, I'm not going to do this. because 3 years and then come back and do postgrad and all that, and then hang out a shingle somewhere and wait for the patients to drop in. So I decided to go in for law, which was always a second choice. But I did it. I was quite happy. And in a sense, I suppose, in retrospect, I'm happier here because I really think I enjoyed myself whilst I was here.
But sir, now you became a senior advocate, I think 1987. How has the journey been within the profession? Like, how did you start? As in, if you can take us to after you finished college, senior, how did you get into the profession?
My uncle was a judge at that time. I asked him who I could sit with. I knew nobody on the original side. And he told me that there was a person called Mukund Modi who was supposed to be good. I'd never seen Mukund Modi in my life, but I went by what my uncle told me and I met him, started work with him. I must tell you a very funny thing happened when I first met him.
Sure.
This was in 1965. When I first met him, I was sitting outside his chamber. I peeped into his chamber and I found this fellow, fairly young, sitting there and 2 or 3 or 4 guys around him. So I sat back in the chair. I had only heard that Mr. Mukund Modi was a judge of Gujarat High Court. If he was a judge of Gujarat High Court, then I guess he should be over 60. So when this young fellow was sitting there, I never thought it was Mukund Modi. So I just sat outside until somebody asked me that, who are you waiting for? I said, Mukund Modi. He's there. I said, no, he's not there. He said, young fellow. He said, that's Hemar Modi. So then I went in. Then I joined him. I must say, he was a mentor to beat all mentors, as it were, because he told me who were the leading lights, what were their peculiarities. I remember he once asked me, gave me a docket of some papers and said, go through this. So it was a small one. I went through in about an hour or so. Yeah, I said, I've gone through it. He said, now wait. Fali Nariman is going to come to argue before me as an arbitrator. So wait. And you'll find that you will learn something. That now you know the facts. And the way he'll put it, the way he'll argue will be excellent. It will be a lesson for you. And it sure was.
Wow.
And Fali came in. We used to have a lot of things to do with the chambers of Nariman, the chambers of Sarabji. One of the incidents on Nariman is Nariman was appearing in a matter and my senior Mukund Modi was appearing in the same matter. They were for different clients. And there was another senior lawyer appearing who was rather well known for flitting from court to court. So in this court, Fali and my senior were waiting. That other senior's junior appeared and said, will you keep it back for a few minutes? My senior is coming. So we agreed, and it was kept back for 2 minutes or so. And the senior walked in. In those days, taxation was 97.75%. So when he walked in, Fali knew that he charges 100 guineas. So he told him when he walked in, Cam, okay. In other words, did you earn your 225 guineas? Because 100 guineas you kept only 2.25, that kind of thing. It was a very good bar. We had some great people at that.
Fairly extraordinary people. And then, so how did most of your practice was on the civil, you chose the civil side?
Normally in practice what happens is, you're conditioned by the set of chambers you're in. Because the chamber is criminal work, then you're in that. If the chamber is civil work of a particular type, then you're doing that. That you get typified. So it was my lot to be conditioned by Mukund Bodhi's practice. That's High Court, original side, civil side, company law, writ petitions, all that. Not too bad. He died young, my senior, but he was great. He was absolutely. I remember when I first appeared in a matter where I had to do some talking. So one is always in tremendous trepidation when you're appearing before two judges who were reputed to have damn good practices before they went on the bench. And I was worried. My senior told me, don't worry, read your brief, I'll sit next to you. So he sat next to me whilst I argued. That it's not that he helped me, but the comfort of having somebody next to you who would be able to guide you if you went wrong was tremendous.
I'm really happy that you spoke about this because I think this is one thing that a lot of people don't speak about. The first time that you stand on your legs before a bench and you have your peer group, your seniors, potential clients watching you. So, you don't even remember what you have to say. So what would you want to say for anyone who's for anyone who's either a young lawyer or young students who find themselves in this situation and they don't have a senior like yours who came and sat next to you? What are some of the ways that they can prepare for this?
One thing I can tell you that if you are clever, if you have a basic intelligence, you are bound to do well in the profession if you have a little gift to the gab. One, in our profession, it doesn't take that you should be a genius to get along. You should be good. You should be intelligent. You should have your wits around you, which I notice a lot of youngsters do have. I don't know how much do they suffer in practice or how much. I don't see too much of it these days. But, and I always tell all juniors, including mine, read your brief thoroughly. All the law on the point must be looked, and then get up in court. You already know more than the judge. He can only beat you in law because you may not know the law as well as he does. But on facts you beat him because you read your brief. So I said, you get up, don't get worried, don't look here, there at all. Say what you want to say. Say it clearly without any great fear. And it works.
Yeah. I think it's, my first experience when I was at the High Court and Farzana was, and she told me, oh, I'm not just manage this, you do it, you know the facts. I forgot everything. I was before Justice Chandrachud. I couldn't remember anything. And he was very kind. But even then, blank.
Yeah.
He was really kind, he knew that I'm a rank junior, completely new.
True.
And he said, but I think that experience, somewhere I felt that I am not good for any kind of litigating practice in terms of, any sort of counsel practice or addressing the court. So it just became such I think a psychosis in that sense in my head that I never would do it. Like even if I would be told just even for simple things like adjournments and things like that, I would know my brief, but I was so afraid to stand up and say something.
Tell you, in the profession, in spite of the fact that you do a spot of work and here and there in briefs and matters of some note and etc. But the first time you get up in cross-examination, you've read your brief, mind you. You've read the law on the point. There's this chap in the box who knows much more of the matter than you do. And he's there to bamboozle you. And you're there to make him stick to the straight and narrow. The first time you get up, it happened to me, I'm sure. It happened to a lot of people. The first time, I didn't know what I was going to ask him. I was just sort of struck by the moment, and I couldn't, for the life of me, think. Then I thought about it quick, because the judges will not take kindly to persons who waste a lot of time. So quick. And once it started, then after I asked him half a dozen questions, then I knew. And the different crosses of different witnesses have not been so difficult at all.
Yeah, so experience helps.
Oh, yes.
Yeah, I think that is a mistake, right? I think when I'm talking about my experience, I did one and then I'm like, no, never again.
Yeah.
But sir, when, sticking with cross-examination as a theme, I know you were also taught at GLC and you specifically taught Evidence Act. It is certainly one of the most foundational laws that any lawyer
Absolutely.
must know. So can you dig a little bit into Evidence Act in the sense that what is probably, I'll ask you a high level question. What do you think is the one sort of Evidence Act principle or evidentiary principle that every lawyer must know before he enters, enters?
One, you must know human conduct, because it's only when you know human conduct that you can think whether the explanation given by the witness stands to reason or does not stand to reason. You must, before anything else and before all this, even before knowing what the witness or his predilections, you must know your brief. I can never underemphasize that. Every single page of your brief must be read. Every single page of the documents which are disclosed by either parties must be read. And they must be read such that when a witness gives you an answer which is inconsistent with what he said earlier in some letter, it should ring a bell. You may not be able to immediately spot where in that compilation of documents is that document. You can look for it. If you have a junior with you, you can ask him to look for it while you go on. But you must know this. You must know that there is something is wrong with this answer. You must know this. And that brings me to question central to all cross-examiners. Never, never, never ask a question, the answer to which is not known to you. So it's not a fact-finding occasion. He's not there to give you facts. The witness is there to ruin your client's case. He's the enemy. You are hardly going to find him trying to help you. He might be subtle. He might be not so much in your face. But you should know that what he's saying is not exactly true. It may be with a little variation, but you can only confront him with, certainly the best would be to confront him with what he said earlier.
Yeah, like any inconsistency.
Yeah, absolutely. Or something which he said earlier, which means something.
Yeah.
So you could reason with him. Or you need not reason with him. You can ask him the next question. And if he's bound to be consistent with the answer he's given earlier. So if he's consistent with the answer he's given earlier, either it is an extension of the first answer or against it. Accordingly, you can proceed in your cross-examination. But this, I can never underemphasize, reading your briefs so thoroughly.
You think it's not happening?
I am not very sure. I'll tell you the reason. Probably when we started our practice, we had very little work initially. By initially, I mean almost the first 5 years of your practice. You hardly had any earnings worth the name. I remember that a senior to me, who became a judge of the Bombay High Court and then of the Supreme Court, was a good friend of mine at the bar, although he was 5 or 6 years senior to me. And he said, Rohit, one test I have for myself is in the 5th year of your practice, if you're not averaging 500 rupees a month, quit. And he said, I averaged 500. That's why he continued. So we were at that time in that kind of situation where even 500 earning was a good sum. Today, lawyers are getting work almost immediately. The reason for that is that there are so many tribunals, so many arbitrations, so many areas in which you can
Practicing.
appear, and there's only so much your senior can do. Therefore, you have to ask you to take something else. This leaves little time to prepare for the law. Comparatively, little time. I'm not saying that their lawyers are not prepared. Of course they are. But earlier it became, since you had nothing else to do, you prepared enough. Like I remember somebody came to my senior, Mukund Bodhi, and asked him in the High Court library, I want to see you for some so-and-so industrialist had an avruddha stri. Avruddha stri was that he had a mistress. And through the mistress he had a child. And after he died, the child, the son, was also claiming to be interested in the property of the old man. He wanted to consult my senior. My senior said, yes, come tomorrow, etc. The chap never came. But I heard this, and I was out of college at that time. I knew Hindu law. I knew there is this Avruddha Stri concept. All this I knew. So I said, I was very gung-ho about it. And I had nothing to do. So when my senior went off for something in court, I took up the Mullah Hindu law and started reading on this Avruddha Stri. And I made some notes. And I put it away in my locker because the guy didn't turn up the next day. The scene shifts to about 3 months later. Again, I'm in the High Court library, sitting next to my senior, and this guy comes along and he says, Mukund, remember I talked to you about that Avruddha Stri problem. Now it's ripe, the matter. So can I see you today? So Mukund said, yes, all right. And I said, Mukund, I've got some note on it, if it helps you. So he says, yeah, what's it? Let's see. And I brought along from my locker and gave it to him. He went through it. It was a 3-page note, not a great long note. He went through it and he looked at the solicitor. He said, yeah, come. I'm ready. So that kind of thing, opportunity to read, willingness to read, and there being nothing else to derail you.
It's also
all those.
What was the lesson that you'd like to pass on from this one incident to someone?
One, work and work. Preparation, and preparation. And have your wits around you. You can really tire people in knot if you have your wits around you. You must be willing to see with your wit, with your knowledge, that he's trying to pull a fast one on you, the witness. Then you should be able to spot it.
Sir, you were also in your fairly long career, you were 2 major cases, I think. One is, of course, the Harshad Mehta scam that sort of rocked the entire financial markets. And then this Yes Bank, Rana Kapoor, I believe you appeared for him, the entire stakeholder litigation part. Now, any such headline-grabbing case, it's a bit more different than any of the other cases simply because of the amount of scrutiny and, or maybe I should ask you, what is different about these kind of headline-grabbing cases?
You see, what is different about the scam, the Harshad Mehta scam, was it was the first time the Bombay Bar had knowledge of the extent of things happening in the commercial world. It was all very well to think that, there's some scam going on. There's some fellows making a lot of money, it's okay. But you never know the kind of detail, the quantum of work which was being put in by these scamsters. I was once arguing a matter before the Supreme Court, and one of the judges there was Justice Sri Krishna. I knew him at the Bombay Bar and Bombay Bench, etc. So I was more comfortable appearing in it. So he said, how many such cases are there involving how much money?
And this is Harshad Mehta time.
Yeah. How many such cases are there? Because Harshad Mehta was one Dalal was another scamster, and we were dealing with Dalal. So he asked me, what's the value, total value of his scam? So I said, yes. And he was a sporting fellow. He said, 50,000, 1 lakh. How much? I said, 1,53,400 crores.
Oh.
They just fainted almost. I said, that's only one person
Oh boy.
in the scam. Yeah, we made a scam of 1,53,400 crores
In the 90s.
in the 90s. So
Just to give context, I mean, 1,53,400 crores in the 90s is like, I don't know, the entire sum of a small country, I think.
Absolutely. We just couldn't imagine the kind of monies involved in this. And then, of course, the bar is a very clever place. Sort of got used to the idea of big monies involved. So that is the scam. And second thing I wanted to say was, I had intimate knowledge of quite a few of these scamsters, including Harshad Mehta and this Dalal chap. They were so nice. So nice to speak to, and so nice to help you.
Okay.
So long as they are not affected. So I had occasion to ask Dalal, in so-and-so matter, in so-and-so fact situation, what do you think happened? So he said, well, this must have happened, this must have happened, this must have happened. But it's not his case, so he doesn't mind talk about. But it helps me to understand. And he was very nice, he was forthcoming, and all Harshad Mehta. And Harshad Mehta had a brother who was a doctor. We had a lot to do with him because when we prosecuted or we had a matter against Harshad Mehta, I never appeared for him. Not anything else, but there was already a complement of lawyers appearing for him. But he used to never attend the court, and his matters used to be attended to by his brother, who was a doctor. We got along very well, although he was on the other side.
Is he the one who then studied law? No.
That's right.
He's the one, Ashwin.
Yeah.
So that it's all,
Ashwin.
It's made very famous because of the documentary.
Yeah.
And then he, I think, advocated for some wrongdoings in the... Yeah.
But it was charming to get along with these people. But of course, at the back of your mind, you can't help that maybe after shaking hands with them, you should count your fingers.
Polite way of speaking, so British. As a lawyer, was anything different in the sense, feel a lot more pressure to perform because of the number of eyes that are on you, number one. And if you perform well, obviously, then your career is fairly set that way because, there's a certain benchmark. From that angle, how do all of this...
I think it almost never affects you.
Okay.
Because when you're a junior, just starting into practice, maybe your first appearance, second appearance, fifth appearance in court, you know that others who are sitting in court could be impressed by you. You know that this is your chance to shine. You're not in trepidation. You're on a high. You want to do well.
So you're saying the same thing that for someone which is seen as pressure, but for you, it is seen as...
It depends on... I dare say some people might look at it as a pressure. As I told you, that the first time you get up to cross-examine, after your number of years behind you, you don't know what to ask him. That's also being dazed, as it were. But it shouldn't affect in small matters and beginnings of your... Once you get used to the idea that whenever you talk, your quality will be estimated by the judge, by your opponent, by his counsel, his solicitor, your solicitor, and all those others who sit in court. So you know you're on show.
You just have to get used to it. That
Then you
and it
get
just becomes like background noise. What about in the Rana Kapoor, maybe in the Yes Bank case? There it was family dynamics, or then some close rather family dynamics. That adds a different layer of complexity to.
Yes, I think because overlapping with all this is has Rana Kapoor cheated the others? That question always was sort of uppermost in mind. But I'll tell you that when it came to an argument in court, the argument in court was based strictly on the corporate law. So there was very little scope for any argument of moral wrongdoing, etc. Although undercurrent, you had this animosity between two camps, but it's all right. You argued everything on a plain old law.
And how, as a lawyer, when you're advising or you get these kind of matters, and because you have to address the human side as well. The court is, yes, you have certain issues, both sides bring up and they argue on those issues, and that's fine. But it's outside of the court, and then while you're preparing and while you're sitting with your client and while you're advising them on strategy, etc., that the human side really shows up. How do you handle that sort of complexity?
I tell you, I have normally found that very few clients want to be told that maybe the other side is right. So you must be careful not to say that. Although you feel that on some questions, the other side might be right. In which case, I found it always very useful to split up on points which are against us. And I tell my clients, I'm not sure about these points. I think they're against us. I think the other side didn't make much of it. If you need to consider about those points which you have to give up and etc., think about it. But it's going to, the moral side, although the temptation is there, I don't think any lawyer would sort of preach to his client.
If not preaching to your client, sir, I guess what I'm probably asking, or maybe I'm asking for a more best practice kind of thing, because when they come to you with complete conviction, right? Like, we are right, and you have to ensure that, that they see that I'm right and they feel. And then how do you temper that without at the same time making them feel that you're on their side?
No, you must listen to them. You must talk to them why and on what basis they think their claim is unanswerable. Why, on what basis? Now, most clients that we have are commercial people.
Yeah.
So they're not the kind of person who blank wall when you speak to them. So they are quite loquacious themselves. Mm-hmm. They can tell you that according to this point, this point, this point. Now, if those points are not very clear or they are against our client, then they must be told. They must be told that you can't hope for all this in heaven to have to get down to, because you have certain points against you. Now, it's all right. We lose those points. If you still want me to argue, I'll argue those points. I think they're against you.
If you are looking back now at your, practice, what stands out, you would say, like, what were the most heartening moments of, if you have to give me 2 or 3?
One of the heartening moments which I remember totally was when I was a junior in a testamentary matter where the judge was against me. I cited a particular judgment and the judge turned. That was okay, not difficult, not unheard of. The judges turned. What happened next? My client and his wife who were in court, they were very modest people. very modest. The solicitor was not there. When the matter was over, the client pressed a note of money in my hand, 20 rupees, as a prize for having argued his matter. So I was touched by that. Difficult to remember the cases, but we do have cases when you get touched by what happens, you get touched by what the opponent says sometimes. Although he's your opponent, but he is still a friend.
Yeah.
Because almost all of us who are in the original side High Court, we all know each other. We all have broken bread together. So it became difficult to really. I know for a fact that, for example, I had a very, very dear friend of mine who died. He and I started practice on the same day. He and I became senior counsel on the same day.
Wow. Would you be able to tell us who it is?
Yeah, Saleh doctor. But he was 1 year older in age. So I told him, he was a very good friend. I said, because of the foresight of your father, you are senior to me. But we kept the seniority. Whenever it happened in 5 or 6 occasions, both of us appearing on the matter, I insisted that he should lead. I'm on holiday. I said, oh, you there used to be, I so far as possible, I never lost my temper in court. Never. I find it's counterproductive. You alienate the judge, alienate the witness whom you are cross-examining, alienate the other side, and it doesn't help. In one matter where Saleh and I were opposing each other, I got rather worked up by what he said. So I got up and started berating arguments. Saleh had the habit of which is elbow on the lectern, he said, just looked at. After about 1 minute of all this, he said, now who's losing his temper?
Oh, sweet. It worked well, but...
Absolutely.
But sir, you spoke about your senior. Sorry, I'm moving. I'm most happy to hear more stories. We all love stories. So if you have more at any time, please tell us. But I wanted to, you spoke about your senior as someone, a mentor to beat all mentors. Can you dig into that a little bit? And then also you have been a mentor to so many people.
Yes,
within
but
the profession.
I've, in all mentoring, I've remembered how I was mentored. And I want to pass on that tradition. Now with the plethora of courts being available, it's difficult to sit with the junior on his first day in court, as it were. At that time, we had only the High Court, nothing else. So it was possible to do, but we do the next best thing. We ask them, whenever there's a problem, you come to us. And people have asked me their difficulties, what is the way out? What is the way of tackling a particular point? And we, almost all of us, make it a point to listen to the junior and his problems. Because you probably were like that earlier. And you probably thought what you think now is a very shallow approach. You probably had the same approach when you were
at that age,
Yeah. So you do well in mentoring. If you remember that you have been through all this, what he's been through, and take it easy. You never berate a junior. You never tell him, why not? I don't do that at all.
What would you say are some of the principles that a good mentor would have?
Kindness and making your advice palatable, conditioned by what you know of the junior. You know what he will like, what he will be reluctant to take. But if you think that even that which he is reluctant to take, he should keep in mind, then you will tell him that. But you will do all that knowing what his reaction likely would be. And treat him kindly. I don't think there should be any problem. Anyone else I must tell you something else. When I joined, Mukund Modi was on the senior list. So Mukund Modi never did drafting work. So one junior, who was the senior most junior in our chambers, had a lot of drafting work. And he did a lot of drafting work. I remember after about 2 or 3 years, first 2 or 3 years, you're nobody. Yeah. A little intelligence is understood by people. So he understood that maybe this guy is somewhat thinking. He started dictating all his pleadings in 3 copies. One for him to correct, one for his solicitor, and one for me. You tell me, you have read the brief, I have written this plaint out, tell me how it is. And then he would discuss with me why he said something else. And when I took it to him, either he followed my advice or he explained to me why you should not say this.
That is such a lovely way of learning as well.
Lovely way of
Because it fosters confidence while teaching you.
Ultimately, I joined that person as a junior after death of M.R. Modi. I joined him as a junior. But I remember those days. Mr. Ashok Modi, he was a judge. We had good times together. He had ants in his pants. At 6:45 in the evening, he would be pacing up and down, ready to leave. I'm not yet ready to leave. So come on now, what's on? So then he would go after 5 minutes. It can't take more than 5 or 7 minutes. Then he would go. I would follow later. And it so happened that our houses were next to each other. I was on the first floor in my house. He was on the second floor in his house. And he would, after those 5 or 7 minutes are over, he would tell me, you do what you like. You come whenever you can. I'm going. But when you park your car, come on for a drink. So I used to do that.
Lovely times.
Lovely time.
So you spoke about all of your memories. And then now we are living in a very, very different time from, the time that you are reminiscing about this. We spoke about how life is very fast, but it's also a bit disconnected because of AI and technology and so on. If you have to essentially look back, look forward and say, okay, what are some of the things that you think is good that it stays in the past? What are some of the things that we should protect at all costs? And what are some of the things that we should adopt now?
I can't think of virtually anything amongst what I think was what any right-thinking member of the profession should have done or did do. I can't think of any practice which he needs to give up, any practice which should not exist today. The practice on which everybody of some note had a practice, enviable practice, was the dint of hard work, the law, the reading up so thoroughly, the background knowledge of human nature. A lawyer has an all-round experience. He knows something about music, something about painting. All this, he is not a musician. He is not a painter. But he knows some things. He knows the good things of life. He might be able to discuss booze with you. He might not be able to discuss booze with you, but he might be able to discuss spirituality with you. So I don't think from the past, I would say any of the qualities that they should not be eschewed. No, continue with what you have done, what the profession has done. And for the future, I could say all these trite things like the law is supreme. You must always wish that the law is kept in good shape. Nobody has the right to go against the law, however high it might be. But with all these platitudes is, I think, a knowledge that in the present society, some things prevail. Power prevails. Money prevails. Power and money may be objected to by somebody in the legal profession, of course, might be objected to strenuously and might be objected to in a way that others could also see it, which is good, but it does not endear the person to
the powers that
to the I do not think. I think there are questions and questions. There are some questions on which, as a matter of principle, you don't agree with it at all. Some matters of some other matters are out of this straight and narrow. But it's all right. In human nature, there are all kinds of people. He is one of those kinds. That's okay. You need not tilt at that time. Consider that as being tilting at windmills.
But sir, say something from the past. We've also had people who've said one of the things that they don't appreciate about the Bombay High Court in particular is the payment made to juniors. That is not something that we've tried to address this in our platform because everyone has a different opinion, etc. But this is one thing that we get asked as well. Why are you not talking about payment to juniors? Because do you have anything to say about that in terms of like what should be kept in the past like that?
I'll tell you. Question of payment to juniors or payment by juniors is probably as old as the hills. In England and in India, in Bombay, when a person wanted to take up chambering with a particular senior, he had to pay so many guineas for that advantage. And that was for being a junior for 6 months. Then thankfully that is gone. We don't find those cases at all existing now. But now cases exist there is no payment being done at the Bombay Bar. And to my mind, that's a good thing. Because payment then makes you think that you are entitled to some work from the junior. We have gone along, I have also on this basis that I have so-and-so as my junior, I have 10 juniors or whatever. They are all entitled to do their own work. They are all entitled to ask me or any other junior in the chambers of his difficulty. They are all entitled to do my work when I ask them to look up the law on one point as a secondary thing. First, his own work. And that junior is very often briefed with you in matters with you. He normally, his earning is by this method, which is, I think, a very professional way of the junior earning. And he is beholden to a senior, yes. But he's still a lawyer and you are still a lawyer, the senior. So I don't think there is much scope for, at least I do not think there should be a situation where your juniors should look upon you as a boss. No.
And so when it comes to present...
In our chambers now, not in my own chambers, in my own of course, but in chambers generally. Everything in the chambers is on the house. So even if there are 10 juniors, 15 juniors, all 15 juniors are entitled to do their own work, hold conferences with their clients. Naturally, they will find ways of doing it. They can't accommodate in chambers. They will find a high court library to sit there. All that they'll do. But everything, all tea, coffee, food, is all available at the cost of the chambers. Not only for himself, for his visitors too. It's all available. So a junior knows that when he enters the profession, the cost of all this entertainment, as it were, would be on him. Rent of a chamber would be on him. And he needs a chamber because he needs a place where he can be contacted by anybody. So he gets this out of this chamber, set of chambers. But at the same time, nobody is my boss. So he is a good man, senior, very good, excellent, etc., good points, all that, but no, he's not my boss. He can't tell me, why have you not done this? No.
That is really the idea of the non-payment, as it were.
And the idea of a professional jollity between the two.
In the present times, one of the things that I'm a bit worried about, or maybe hopefully we will be able to do something about it, is the very rapid trust deficit that we are seeing people with vis-a-vis the legal or the judiciary in general. And then, I'm not entirely sure. I was very excited when, you have all of these live recordings and live streamings of various in various courts. I'm not entirely sure what is the value of how it has translated in public outlook towards the profession. I'm saying with the context of fading trust. What do you have to say about that?
Outlook towards the profession always has been, that was a way of speaking. Not that they really considered lawyers as to be. Some did, but most didn't. So far as the judiciary is concerned, it's a very sad commentary that the judiciary today does not display the same spine that it should earlier. The same spine which would have told a judge that he can behave the same manner with a powerful man as he would with an ordinary pen pusher. That is not. This deference is more evident now as it is than earlier. In America also, I should think this had lessened, this fearlessness, etc. But I'm glad to see the recent YouTubes about Trump and the judges. I find federal judges, not Supreme Court judges of the US, standing up and saying, this is nonsense. This to a sitting president, if you could use words like this. You are in contempt. I will see that you are arrested if you do this further. Even to say it requires some kind of spine. And that is not displayed in public life. Then the common man does think that he doesn't have the judiciary on his side as it used to be earlier. He doesn't have the ability to go to court and rest assured that his case will be heard, his plea will be heard. Maybe he'll be decided, the court might decide in his favor or maybe against him. But decide they will. And the judiciary will give him reasons, which reasons will fill in, will answer most of his problems. If he is biased, he will not see something. But quite a few others who know the facts, but they are not biased, will look upon it as a correct decision. That kind of discernment, I think, is a bit missing in our judiciary.
How can we help? Is there any way that
Yes. One thing is, you must be very, very clear that even when you start practice, your senior is to be venerated, but he is not my boss. You have that feeling. When you become a judge, you know that you owe your salary to the Union of India, but they are not your boss. However powerful, however, you are there to do your job. Do it. And don't worry about what happens. It might be in a large number of cases, one might answer, easier said than done. But when a person stands up for what is right, he stands out and he finds acceptance. And I think that itself is a reward. If you should be able to tell yourself that you didn't take this line down, you didn't take this, you're not blinded by the power or money of the man, you did what was right. I think this, from the very beginning, if it is inculcated in our juniors, that you are member of what we call the honorable profession. If you're a member of the honorable profession, stand up and be counted. I think that's all that they need.
And last question to close this section is looking back, if there's one thing that you would want to leave as, or people to remember as a legacy, what would you want?
I would remember one thing in great detail. A person went to an optometrist and he was given that chart to read. So he read, you are witty, intelligent, beautiful, handsome, and smaller letter. And awfully conceited if you believe all this. So remember, everything has to be taken with a pinch of salt. But go by one thing which I have also been told. Do what you think is right. If you do that, maybe you're right, maybe you're wrong. But you have done what you think is right.
And what is the one legacy you hope that people remember you by?
The optometrist.
I'm going to steal that. Okay, the last part of the podcast is shorter answers, quicker answers. So we call it 5, 4, 3, 2, 1. And we ask you 5 of something, 4 of something like that. So this I do for myself because I love hearing the answers that people give. So, ready? We can start?
Yeah.
Okay. 5 productivity tips, routines, things that have helped you in your life.
1, reading. 2, watching around with how people react, how you react also, being totally prepared. I think if you have the fear, which I have, how could you, if the judge asks you, Mr. Kapadia, where is this stated? You may not know the page of hand, but you do know it is stated on the record. You do know, and you must know, it is stated in the record. It is stated as a weak point against you. All that. How can you get up in court and tell the judge, I don't know? Your brief, you must know. How can you ever say?
When you say being prepared, you mean only within the confines of, your work, or generally being prepared for it?
No, generally being prepared, but you must remember your work first. Generally being prepared is part of general knowledge, part of being a man of the world, part of experiences in different fields, not professional exercise, but in different fields. Like I said, you go to movies, you see this, you see that, you go dinners, you have a drink here, you drink there. All these are scopes of life or things of life. But work is first. And in work, preparation.
Sorry, I stopped you. Please continue. You gave us 3.
Then I don't think anything else is required. I think just a modicum of, yes. Never be reluctant to speak what you think. It might be foolish, but it might be a whole new way of thinking, which you as a junior might have contributed to. We had a scam matter recently meaning a few years ago.
It's not you're not talking about the Harshad
Mehta scam. Yeah. When Justice Kapadia was in the Bombay.
So Justice Kapadia, do you want to clarify that is not...
No.
Yeah, you want to clarify.
He's a Parsi.
For the world.
In the matter, the senior counsel appearing were Rafiq Dada, Janak, myself were Mahendra Shah, that I can think of, besides host of other juniors. And one by one, we cross-examined a particular... I was the last to cross-examine in turn. And before my turn to cross-examine came, probably the junior-most lawyer in our team said, why can't this be the case? I thought, he's got a point. Why is this not the case? I couldn't ask him because it was not related to my case. And the time had gone when earlier it would not been asked. But we all thought that that is a question we should have realized ourselves. But of course, I papered over the difficulties by taking him back to what he said in answer to so-and-so's witness evidence and so-and-so counsels, and got back to that, But the kind we have to, the best way of doing it was to ask him at the moment. At that time, it never struck any one of us, but the junior most chap.
Yeah, but it is also intimidating when you're sitting in. I guess that's the point that you're trying to make.
Correct. But the point I'm trying to make is don't be intimidated. If you know you've done your work, you know there's a particular satisfaction which comes when you have done your work, when you're ready. Maybe unthinkable might happen, some questions might deter you, but you're ready. You are ready to it. If that is so, then just don't get scared to speak. No trepidation. Nobody is going to turn you down. Nobody is going to kick you in the stomach. No. So that's a question which I think should be remembered.
Okay, 4 books that you'd recommend anyone should read. And it need not be law books.
The Art of Cross-Examination is a book which must be read.
And even by lawyers who are not litigating.
Absolutely. By lawyers, the first 3 chapters of Woodruff and Amirali on evidence. The first 3 chapters, the authors give you what the law of evidence is. And I found it a most disarming way of explaining it to the layman, to everybody. He says the Evidence Act is one of the most logical pieces of legislation. And he says it concerns itself with 3 questions. What can be proved? That's relevancy. How is it to be proved? Documentary, oral, etc. And who should prove it? If you answer these 3 questions, you can't go wrong in that decision. So I think that is a must for anybody who wants to practice in the High Court in litigation. He must read the 3 chapters of evidence. 3 books. One book by Harari has stuck in my mind. Harari was the anthropologist of
You're talking about Yuval Noah Harari, right?
Yeah.
And then 21 lessons in the 21st century.
His sapience is, I think, rarest of insights.
True.
In fact, I started marking it, because there's so many quotable quotes in it.
Correct.
I think he's one of the most outstanding authors. Then otherwise, there are a lot of good books and lots of pastime books, like detective novels and thrillers and things, They're all good, of course. But Harari is something else. That and the very ambitious, I would wish best of luck to anybody who would try it. The story of philosophy, the history of philosophy.
Okay.
Will Durant, 10 volumes. But I have not read all 10. But I read the one on India, on Asia, and excerpts of something else. But he's written a book on India, a book on India.
And this is not history, it's only philosophy.
No, it's history and philosophy.
I guess you can't.
But he's written this on India when he was here, when he visited India, around the turn of the British regime in India at that time. So I'm talking about 40 years of. His book is something which every Indian should read, because it tells us how we went wrong. Why we allowed ourselves to be ruled by a small number of people. Why were we deficient in our brains? No. But we were systematically, as Tharoor points out in his speech, systematically denuded of our wealth. Nobody could say a word at that time. So, should read that book.
What is it called?
On India.
It's called On India. Oh, I see. And one last book. You gave us 3. So, the most recommended book on our podcast is actually Bhagavad Gita.
Yes. But I must confess I have not been able to read all of it at all. But there is one, if anybody is interested, then there are books on history written in India. I believe there is somebody called Panikar. Those taken a large expanse of the years when different rulers ruled India. But still, I think nothing like Harari. Harari takes not when the rulers ruled,
Yeah.
how India came in.
Yeah.
Okay.
And very, very deep. Extremely deep.
Very deep.
Yeah, I agree. 3 ways that travel changed you or helped you in your profession also.
One, it helped me as a person. I don't know whether it helped me in the profession or not, but it helped me as a person because I could see the way different countries are, different people talk, different people behave. It's I'm not a psychologist, but you get to see different. You get to see it even in India, in places in India itself. A divergence of culture, divergence of belief. See that also. But don't confine yourself to only India. There's so much of the world to be seen. There's so much to be seen in different kinds of life, in different kinds of thought, in different kinds of government. So much to be seen. So I think you never do anything to take away those opportunities. After I started doing reasonably well and could afford to take holidays, I first holidayed in India because that was the limit of affordability. Then I started holidaying abroad. And like my holidays in India earlier, my holidays abroad after I could afford it were in all 3 vacations. And that stood me in great stead. I think I would unhesitatingly tell everybody, not merely lawyers, everybody. Travel, see the world.
So, one, it gave you perspective. What are the other 2 things it did for you?
Other 2?
Things it did for you. Because 3 things, 3 ways.
They gave me perspective. And one, apart from perspective, again confined to our legal system. Because we can't help look at things biased by our knowledge. So you do appear to, you notice how the law is treated differently in different situations, how it is treated differently in different cultures. Most strikingly, the entire English law or the Anglo-Saxon jurisprudence is based on one fundamental belief that a man is innocent until proved guilty. The entire body of administration of justice in Europe, the droit administratif, believes that the accused is guilty until proved to be innocent. And both work very well. There are no excesses in Europe that you can think of. In Europe, there's another difference in droit administratif, where the judge is like a prosecutor. Here you have in the Anglo-Saxon jurisdiction, never descend into the arena of conflict. Judges are supposed to be aloof. Hear a case before them, will not take part. There they do. Both systems work well. Now it is, when you see it, when you think of it, when you try to get examples of it, then you realize how different things could work, how different views so opposed to our way of thinking could also be right.
So it opens up your mind.
Absolutely.
And allows you to be more accepting. And the final, just to maintain the symmetry of 5, 4, 3, 2, 1, I'm asking you to give a third.
Travel, the greatest thing amongst the greatest things. No, I couldn't say greatest thing. I find in travel is to partake of the foods of different countries. I'm a foodie, so I enjoy foods of different countries. I eat meat also, so my experience is not limited. I've eaten crocodile meat also. That's exactly what I felt after I ate. But when I was in Africa, in East Africa, in Nairobi, there is a place called...
Carnivore?
That's right,
Yeah.
carnivore. Carnivore had all kinds of meat.
Yeah.
crocodile meat, camel's meat, but I did crocodile's meat and then I lost the enthusiasm to try. But you must see exactly how even simple things they can make interesting.
2 life lessons you have learned in your life so far through your own life experiences.
One, give all help to the juniors. Remember how you were helped by your seniors. Never forget that. And 2, no junior must ever say anything which is not true and known to be untrue. Unwillingly or unwittingly, you might say things which are not true. But if you know something, there's a tradition in the Bombay Bar that when you look up the law, if there's a binding judgment by the Supreme Court or the Bombay Court, which binds the judge, even if it is dead against you, you have to show it. Because you are an officer of the court. You are as much concerned in development of the law. You are one of the bits of development of the law. How can you lead the judge astray? You have to tell him that this is the law on the point. And I think juniors must always remember, there is nothing like being one up by keeping that judgment away or nothing of that sort. On the contrary, I find that I've seen that happening in court. I've seen persons getting up and saying, there is a judgment against me. And it endeared themselves to the bench, to the law, to lawyers, to people in court, and they did the right thing. So that must be always taught to juniors.
And the last question is, what is the best piece of advice you've ever received?
Flippant manner? Now, flippant manner, after that matter in which I earned 15,300, which I told you about, 100 rupees a day. After I made 5,000, 50 days had gone by, I told my senior Mukund Modi, I'll buy a scooter. So I said, don't do it now. So I thought maybe this guy doesn't know. Scooters are 3,000 rupees. At that time, the cost was 3,000. So he said, no. So I told him, Mukund bhai, scooters are 3,000. He says, I know, don't do it. Why? Wait till you earn 10,000 more. You must have money for hospitalization. So ever since then, I've never ridden a scooter or a motorbike.
I did the non-flippant manner, like the...
Non-flippant, the only advice I can is fearlessness. Fearlessness. Everybody has advised, all seniors have advised before that. Do the right thing. And even if it means that you are unpopular, do that. You have yourself to answer. You have yourself to answer to on a lonely night. Have you done or have you failed?
Thank you, sir. I think we can keep talking because you have so many stories to say that it's just interesting to sit back and hear you. But thank you so much.
Not at all. My pleasure.
To this. This is our first recording in 2026. Do you have anything? Did you have a good time? Do you have anything that we missed, that you think we missed talking about?
No.
You're good.
I think it's so wide-ranging. In fact, you people have covered a whole subject, I think.
In 1 hour, little more than 1 hour. But I hope this reaches the audiences and we are all able to do some positive.
If all your audience remembers only one advice, do the right thing.
Yeah. Thank you. Thank you for watching. Keep watching us and keep writing to us and share, subscribe to all of those nice things. And I'll see you in the next video.